the Suffolk Academy. Another program presented by the Suffolk Academy of Law. Tonight we're doing our program. I'm Jeanette Gravy, and our speakers tonight are David DePinto and Henry Montag.
I'll pick it up.
Tonight's program is preserving life insurance assets earmarked for the next generation and what attorneys need to know to advise their clients. David DePinto is our attorney speaker for tonight. David is an attorney. He has a master's of law from NYU Law School. He's a certified public accountant, a CPA, and a certified elder attorney. He's one of the preeminent Suffolk County estate planning and elder law attorneys, and he has a lot of good information to share with us. Henry Montag has an organization called TOLI Center East, and they advise trustees with respect to managing, auditing, and running their trusts. He's been a certified financial planner for 30, how many years? Long time. And he's extremely skilled in how to use insurance for individuals, for trusts, and how to best maximize people's assets for themselves and for their heirs.
Okay. Thank you, Jennifer, and
I do want to say that questions are welcome, but before you can ask a question, you must come up to the microphone so that you can be heard by the audience watching online.
thank you, Jennifer, and thank you, out here, Dorothy and Eileen, and thank you all for joining us. We have a good amount of time to cover some information, and I'm going to try to share some 30-some-odd years of stuff that I've picked up, and hopefully this is going to be a good opportunity to answer some of the more basic questions. And I'm sure that I'm going to be saying a couple of things that are probably going to be surprising to many people. As a matter of fact, not too long ago, back in January, I spoke in front of the Nassau and the Suffolk Stateside CPA's annual symposium. And when I mentioned some of the things, I could see a couple of heads in the background saying, no, that doesn't sound right. Well, I welcome that kind of interchange to be able to share some ideas and to be able to share some facts and separate it from some fiction at the same time. So without further ado, let me just talk about what we're going to be talking about. I'm going to try to bring you back to the mid-1980s. I started my career back in the mid-70s. And in the early 80s, if anybody remembers what the interest rates were, remember when President Reagan was here, President Nixon was here, we had interest rates approaching as high as 17, 18%. And that caused havoc in the insurance industry. And what I'm going to do in a systematic way is to try to explain exactly what that havoc quietly caused then and what it's currently doing today. I'm going to be speaking about that from the perspective of both the insurance agent broker's point of view, as well as the attorney's point of view, the bank trust officer's point of view, as well as the CPA's point of view. Oh, and not to leave out the person who basically handles the full responsibility on their own shoulder the majority of the time, and that's your individual clients' sons and daughters. The private trustee, or sometimes referred to as the amateur or the unskilled, or really some terrible words to describe the trustee, but yet that's really what we're dealing with. And then of course we're going to be speaking about the institutional trustee. Of this subject of trust-owned life insurance, anyone have an idea of the magnitude of the amount, the dollar amount that we're actually speaking of? I mean, is it $1 billion? Is it $2 billion? Is it $100 billion? Anybody have any idea? Anybody want to take a guess? Are we speaking about something rather small, medium-sized, rather large? Anybody? That's a lot. Yeah. I mean, I've heard anywhere from $2 to $3 trillion of this trust-owned life insurance. And of the private trustee, well, let me back off for a second. On the institutional trustees, the U.S. Bank and Trust, the Bessemers, the Wilmingtons, the Delawares, how much of this trust-owned life insurance do you suppose they actually manage or in some degree of control over? Anybody take a guess?
10%.
Well, that's right on the money. It's 10%. And therefore, the other stuff, the trustee, the private trustee, the amateur trustee, they're basically handling the other 90%. Okay? So let's take a look and see what a typical situation might have looked like back in the mid-80s. Keep in mind, interest rates were very, very high. Many people were leaving the whole life insurance because why? Why would you or why would a client have left? Because the interest rates payable at a bank or a CD or any of the other things that were available were roughly in the vicinity of 16, 17, 18%. How much were people earning in their, at the time, whole life insurance contracts? 4%. Yeah. Basically 3%, 4%, depending on the company. So, do I keep my 3% or do I physically just go to the bank and deposit my money, and in addition to getting 3, 4, 5 times as much, don't forget, what would you also get if you go to the bank? You had to be there. The toaster made more deals than anything else. But yeah, people went and they got the toaster, plus the additional percentage rate. So, the insurance industry, not being a dummy, they said, well, we've got to somehow stop this tremendous outflow because people were, in fact, leaving the cash values of their insurance contracts and going into the banks. So what did the insurance industry do? Heretofore, there were only 2 types of contracts. There was this thing called whole life, which was guaranteed, and it only paid you 3%, but it was guaranteed. And then the other extreme was something called term insurance, which most people knew was temporary, because all term insurance back then ended when somebody was 70. Today, term insurance ends when somebody is 80. But still, term insurance, if you had a 5-year or a 10-year or a 20-year term insurance, it was guaranteed. If you had a whole life insurance, it was guaranteed. So, what did people do? They left the whole life and they went to the bank, and what the insurance company did said, we're going to stop this outflow and we're going to create a new product, something called flexible premium life insurance. It takes into account the variable life, universal life, the adjustable life, the indexed life. I mean, there's 5 names for it, but it's basically, it's all the same thing. It was not guaranteed. It paid a higher interest rate, but was not guaranteed. So, here's the scenario. Back in the mid-80s, somebody, not me, but somebody is speaking to their client and saying, Mr. Jones, Mr. Smith, I understand that you want to buy $1 million worth of insurance. Okay? Do you want to purchase this continuous whole life, or are you, like everyone else, and interested in purchasing this flexible premium, this universal? Well, guess how much of the insurance that was sold between the mid-80s and 2005, guess how much of that was of a flexible premium, non-guaranteed nature? 85%. So if your client or you purchased the contract, the agent or broker almost didn't have to ask the question, do you want the old whole life paying 3%, or do you want the new paying 16, 17, 18% flexible premium? The question almost didn't come up. So, question became, Mr. Smith, you want to purchase $1 million worth of coverage? Next question, Mr. Smith, how long would you like this insurance to last? What do you mean, how long do I want it to last? I want it to last the rest of my life. Well, the longer you want it to last, since this is interest sensitive, the longer you want it to last, it's going to cost more money. The shorter you want it to last, it's going to cost less money. Oh, well, since you put it that way, I guess I don't want it to last until 120. Give me some prices for age 90, 95. And that's what we did. We gave the client a price based on how long they wanted that insurance to last. And in most cases, most people, somewhere between 92, 93, 94, 95, they didn't want to spend the extra money to insure themselves up until 121, because once they realized that it was going to cost them extra, they're probably not going to make it to 121. As a matter of fact, many people, most people, didn't even want to wait until age 100. They really figured somewhere between 90 and 95, you know, I'll call it a day. I'll retire. So the next question was, Mr. Smith, since this is an interest-sensitive product, what interest rate shall we use? Now, keep in mind, this was when interest rates were 16, 17. They went as high as 18.3%. What interest rate shall we use? Well, you know, paying 16% today, I don't think it's going to last at 16% forever. But back in 1984, 1985, no one really knew how long interest rates would stay up at those meteoric numbers. And many individuals were purchasing mortgages based on that, and were unfortunately locking in mortgages back at back at 15, 16%. So it wasn't unheard of. So oftentimes the client, prospective insured, would talk about 14, 15, 13%, and if the agent or broker was worth their weight in salt, they would try to bring the client a little bit down to earth, recognizing that these numbers are medium, they're high, and that they're probably not going to stay this long. And the agent or broker would try to bring the numbers down somewhat. So the more conservative would be looking at 10 or 11%. The ultra-conservative would be looking at 9 to 10%. There were very few people when interest rates were 16, 17% that were actually looking at a number below 7%. So let's assume that we got the client to consider a 9% number. Okay? So we know how much insurance he's going to buy, $1 million. We know how much insurance, or how long rather, he'd like the insurance to last, and we knew approximately what the interest rate was. Well, now that an agent had those three pieces of information, he or she was able to go back to their computer and was able to generate an illustration. Assuming, based on this interest rate, which might have been 9 or 10 or 11 or 12%, at $1 million, and the insurance would last until that age that that client wanted the insurance to last to, and lo and behold, there would be a premium. Okay, so now we have the premium, and in this case, there was a premium of approximately $14,000. So, we had a premium of $14,000. Back then, everybody remembers, I'm sure, what the marital deduction was. It wasn't 5.3 something. Back then we were just coming off of the $250,000 maximum marital deduction, and we of course asked the client to tell us who would he or she like to own the contract, simply because. Look at that, right? No. Yeah. Yeah. Okay. All right. No, what I was trying to do is use this thing. Do we have one on you? Perfect. Great. Thanks. Okay, so in this case, the premium was approximately $14,000. All right? Now, $1 million, we want to make sure that we didn't include in the estate. So the good insurance broker agent asked the client, and he or she asked his accountant or attorney, who should we name as the owner of the policy? Because we don't want to have you be the owner and have the additional monies included in the estate. Well, let me select my oldest son. Naturally, he was well qualified to deal with $1 million of life insurance, but in many cases, it was the oldest son or the oldest daughter. Okay, so we have the trustee, the application then gets signed, the trustee signs it, hopefully a couple of weeks, months later, the insurer is examined, and lo and behold, we have an insurance contract. But at any point, did that trustee talk about how long that insurance would be guaranteed for? Were there any conversations between the agent, broker, or between the grantor and that trustee in terms of changing interest rates in the event that interest rates changed from their 15, 16% or 9 or 10% or whatever the assumption was? No. Did the trustee have any specialized knowledge or skills needed to understand the internal workings of a universal life insurance contract, something that at the time was brand new? No. Okay, let's take a look at the situation 27 some odd years later. Mr. Smith is now 87 years old. The assumed 9% rate, as many of you will attest, didn't really hold up, did it? It was closer to 4.56% over the last 20 years. Currently, based on the $14,000 premium that insured assumed that he or she was going to earn back in 1987 or whatever the year was, based on that premium that hadn't been adjusted over the last 20 some odd years, the insurance is now going to end. Is now going to end in 2 more years, not when the insured is 95, but when the insured is 89. In other words, the reduced interest rate over the last 20 some odd years caused the variable, and the variable was the length of time that this insurance contract would remain guaranteed in force. So now here we are with Mr. Smith or Mr. Jones having paid a $14,000 premium for X years, and now he or she is faced with, do I pay the $26,000 premium instead of the $14,000 that I had been paying all along? If I don't, my $1 million contract will expire in 2 more years. Now, this isn't just the make-believe Mr. Smith and Mrs. Jones. These are your clients, I guarantee it. These are your people that are experiencing this. It's just that whether it's happening or whether it's beginning to happen is just a matter of semantics. The roller coaster, the train has left the station. It's on the way. It's just a function of how old the individual was, how long he assumed that the coverage would last, what the interest rate was. But it's coming. It's coming. There's no question about that. So one choice is that he could have increased his premium to 26, or he could have decreased his coverage by about 55%, kept the same $14,000 premium, kept the coverage guaranteed till age 95. However, instead of that $1 million coverage being intact, it would now only be approximately $450,000. These are real numbers, real situations. Just before I get any further, any questions on this? Because this is kind of going to be a basis of some of the other things that I'm speaking of. So if there's anybody that doesn't believe this, or if there's anybody that has any questions, no, let me just, we have some time, so let me just hear if there are any questions. Okay, so what did the attorney do in this situation? The attorney did a lot. The attorney gathered all the relevant data, reviewed the client's intentions, even discussed the names of the beneficiaries, their qualifications, hopefully discussed the administrative duties for crummy provisions, and certainly discussed some of the roles and the duties of the trustee. Did he or she really discuss the performance evaluation or the need to monitor or the need to adjust those annual premiums if in fact interest rates went down? Was this conversation on an ongoing basis where every few years the attorney brought his or her client into the office and had that conversation? CPA, again, fine job in terms of really, a second set of eyes. Do you think it's okay to name this person trustee? Do you think it's okay to name this person beneficiary? And he or she, of course, prepared the various gift tax returns and hopefully coordinated with the attorney's office and did the crummy provisions at the same time that the gift tax returns were filed and keeping up with everything else that needs to be done. But usually didn't get involved in the fact that there might be some sort of ongoing adjustment in the premiums that would need to be paid. The private trustee's role, the son, the daughter, the unskilled trustee. Again, very simply, it's an honor to sign, not really understanding many of the fiduciary liabilities that he or she assumed, certainly not knowing any of the internal workings of an insurance contract. Certainly no one ever described to him or her what he or she would need to do in terms of keeping that insurance contract relevant. And often the trustee, just like the grantor, would take the insurance contract, file it away at the bottom right-hand drawer, never to be looked at again. Why? Because it's assumed that life insurance is a low-risk asset and that it's a buy and hold asset. You just buy it, you put it away. Why? Because in the past, for all these years that whole life insurance was around, it was guaranteed. For all these years that term insurance was around, it was guaranteed. There was no reason to manage a whole life contract, for the most part. I mean, obviously there are exceptions, but for the most part, it was okay to put away a term contract. It was okay to put away a whole life contract, but it was not okay to put away a flexible premium adjustable life contract simply because it was not guaranteed, and simply because in the haste of insurance agents and brokers, in many cases, to talk about this new insurance contract, they discussed the amount, they discussed the rates, but unfortunately, oftentimes what was not discussed was the fact that, by the way, this contract is not guaranteed, and you or your trustee or the owner, whoever that may be, has assumed 100% of the performance risk on that contract. And if you weren't right about what your performance expectations were, then the danger would be that your contract would expire years earlier. That conversation wasn't had by most people. And unfortunately today, many people are left holding the bag. So let me just break for a quick second. I've said a couple of pretty interesting, controversial things. Any questions, anything that I've said that bothers anybody, anything that might not be accurate or true? Anything that just needs to be discussed and talked about? Sir?
How many of these types of life insurance policies are still out there, do you think? And don't they send a yearly review?
I'm absolutely going to come back to that question, sir. Don't they send an annual review? Yes, they do. Let me just address right now. The insurance industry has an obligation. Their obligation is to send out an annual review. Where does that annual review wind up? In that same bottom right-hand drawer. Doesn't the insurance industry have an obligation? Doesn't the agent or the broker have an obligation beyond that one annual statement? No, they do not. The agent broker is contracted with the insurance industry, and his or her function is merely to distribute, not to help manage. The insurance company, think about this for a second. Whose side are they on? Do they really care if you or your client's $1 million life insurance contract all of a sudden gets reduced down to $450,000, or if it becomes so prohibitively expensive that the client basically gives up the insurance? They've taken those premiums and put them in their pockets year after year, and now at time of payout, they don't have to make a payout. That's pretty good news for them. And that's unfortunately the situation that we're faced with today. Anything else on that point? Okay. So what are some of the additional issues for the trustee? Well, now again, this is the institutional trustee. If the interest rates aren't performing, they have a duty to obtain the information or to obtain the necessary skills. That's not me saying that. That's the Office of Control of the Currency saying that, revised August of 2012. And I think David, in a little bit, will be speaking a little bit more about that. They have to look at the company's financial statement. They have to look at the financial health of the company. Again, they should be looking at the individual policy and seeing whether or not the current premium is sufficient or adequate to be able to continue that life insurance in force. And they've also got to be aware that costs are always being reduced on the part of the insurance industry. One of the biggest boons to the insurance industry, believe it or not, was the unfortunate creation of the AIDS virus. because back then when that happened, all of the insurance companies began demanding blood samples from their insurers. And when you take a blood sample, you're not just checking for AIDS. You were checking for various medications, for various other illnesses, and as a result of that, the insurance industry was able to do a very, very good job of increasing their mortality selection and decreasing their mortality risk, because they now had a lot more information to base an information on, and it came as a result of that. So the point is that there are various cost-cutting mechanisms that the insurance company put in place, and individuals who may have been sitting there with a contract for the last 20 years are not taking advantage of that. There are new features and benefits that I'll talk about in a few moments that weren't available prior to January of 2011. So certainly somebody back in the 80s, 90s couldn't possibly be taking advantage of that. Okay, so as we said, the good news, bad news about the trustee, just to summarize for a moment, he or she accepted the honor, but unfortunately also accepted the blame if anything were to take place that were derogatory to the family's life insurance, estate, or fortunes, and that's where we are today. Okay? So, as the senior trust officer for U.S. Trust this a little while ago, and I think the answer without my even having to read it is pretty obvious. His words were, if anybody treated life insurance the way they treat, or if anybody treated, let me say this way, if anybody treated a stock or a bond portfolio the way they treat life insurance, they'd be fired, they'd be censured, they'd be kicked out, and if they were FINRA licensed, they'd probably be fined. So if somebody's managing $250,000 or $500,000 life investment portfolio, and they do everything they need to do, you know, that's great. But yet, if they're managing $1 million or $2 million life insurance contract, and they're not giving it the right time of the day, they can absolutely be and should be criticized. But they're not. That's the fact of the matter. They're not. And that's one of the reasons that I've asked David to join me today and to be discussing this, because it's one thing hearing it from me, but I think when you begin hearing some of the actual court cases and what the courts have done, you may begin realizing that, gee, this is something not only that I should be looking at, but something that I want to be looking at, because your clients, think about this for a moment, there's nobody advocating for them. The accountant is busy doing his or her job, you're busy doing your job, the trustee is sitting there in the middle, the life insurance agent or broker, one, may no longer be in the business, or two, may no longer have an interest, doesn't have an obligation, to go back to his client and say, by the way, that $10,000 premium that I suggested that you pay 15 years ago, today is actually a $22,000 premium if you want to keep the contract in force. They're not having those conversations, and as a result, clients are being left holding the bag. Okay, so just to summarize for a moment. Interest rates decline, trustees have neglected. The variable is that the length of time that the insurance contracts remain in force has been shortened by anywhere from 5, 6, 7%, 7 years, hard years. Years between, the difference between age 95, when somebody may actually be collecting on the insurance contract, and age 87, 88, 89, which today is the new 77, 78. Now, the last thing people are doing today is thinking of, you know, at 87 or 88, you know, I'm done. You know, how are you done if you've paid in several $100,000 and you've now got a year or 2 years? You're not going to accept that. You're going to somehow look to pay the additional premium if you can. And there are some people who just say, I've had it. And they pull the plug. And they sure show the insurance company, don't they? No. They're showing themselves. They're not hurting the insurance company one bit. The insurance company doesn't care. If your client decides he or she is no longer going to pay their premium, I'll show them. Could care less. And that's really the key right there, that no one advised that trustee or no one advised that private owner. This doesn't have to necessarily be only for trust-owned life insurance. Keep in mind, the trust-owned life insurance or the individually owned life insurance, privately owned life insurance, it's the same life insurance. It's just a function of who holds it. But the underlying asset is exactly the same. Okay, I just mention this here because David is going to come back in a little bit and going to talk a little bit more about the UPIA and the old man rule. So I'm going to